Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division, draw near, give your attendance, and you shall be heard. Please be seated.
Okay, good afternoon, everybody, and welcome to the Appellate Division First Department. Nice to see everybody. I am going to call the calendar. I'm not going to give anybody a chance to respond. You know how much time you've given. I'm just going to go over that because not all the lawyers I know are actually in the courtroom. So we'll just go over this quickly. People versus Miguel Malave is submitted. Unitrin versus Cohn and Kramer is submitted. G. Ada is submitted. ARPA versus 245 East 19 Realty. The appellant has 5 minutes and 2 for rebuttal. Respondent 245 East 19th has 4 minutes, and respondent Schindler Elevator has 4 minutes. Rodriguez versus City of New York is submitted. Duggar versus Conrad is submitted. 1 Bryant Park versus Permastelisa Cladding. The appellant has 5 minutes and the respondent has 5 minutes. McGowan versus Clarion Partners. The appellant has 6 minutes and 3 for rebuttal. The respondent has 6 minutes. Sunan versus Klein is submitted. People versus Kedvin Vasquez, both of those motions cases are submitted. Niambu versus Whole Foods Market is submitted. A. Children is submitted. Cortez versus Ventura. The appellant has 5 minutes and the respondent has 5 minutes. CHA Design Export versus Miller. The appellant has 5 minutes and the respondent is submitting. Singh versus Manhattan Ford is submitted. Broer versus Lepore. The appellant has 8 minutes and 2 for rebuttal. Respondent Lepore has 5 minutes, and respondents Arnold, Black, and Mid Reviews has 5 minutes. Patain versus Tan is submitted. IKB International versus Credit Suisse and Morgan Stanley. The appellant has 7 minutes and 2 for rebuttal, and the respondent has 7 minutes. And the last case, Benson versus Port Authority. The appellant has 5 minutes and the respondent has 5 minutes. So you know we've had an opportunity to read the briefs and are familiar with the facts of your cases. So just try to get to the issues, and we'll all try not to talk over each other and understand each other with our masks. The first case for argument, ARPA versus 245 East 19 Realty. Okay, you may begin.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff appellant. I believe there are 3 issues in this case. The first dealing with serious injury under Hutchinson and Trinseri. The second dealing with the ANSI regulations, which I think are governed by your decision and the Court of Appeals decision in Bradley. And the last issue deals with causation. Let me talk about the Hutchinson decision first. Unfortunately, it's a decision I know well because I'm the one of the plaintiffs who lost the case, although the other 2 did. My adversaries, as I read their brief, take the position that the physical condition of the surrounding area is not necessarily dispositive with respect to the issue of triviality. And I would suggest to you that that's not what the Hutchinson court said. If I can quote the decision, numerous factors, quote, may render a physically small defect actionable, including a jagged edge, a rough, irregular surface, the presence of other defects in the vicinity, poor lighting, or a location such as a parking lot, premises, entrance, exit, or heavily traveled walkway where pedestrians are naturally distracted from looking down at their feet. And on the following page of the decision, the court notes, and I'm quoting, it's on page 79, our survey of such cases indicates that the lower courts appropriately find physically small defects to be actionable when their surrounding circumstances or intrinsic characteristics make them difficult for a pedestrian to see or to identify as hazards or difficult to traverse safely on foot. If the court would look at the photographs that we have in the record, I think they're pretty good. There are color photographs on 1467 to 14...
Counsel, I did look at those photographs, and it wasn't entirely clear to me how close the protruberation, or the pipe, said to be de minimis, was to the sheave and to the ropes that the plaintiff caught his hand in. Like, how close was the defect to the machinery that supposedly made the defect amplified its dangerousness?
Right. It was close enough that when he tripped with his right foot, he fell right onto it. I understand your situation, Judge Mouton, because if you look at 1425, that photo makes it seem like it's far closer than the photo on 1467, which makes it look longer away. I think they're just different angles. But this is right there. I mean, his testimony was he walked, he tripped, and his hand went right into the unguarded portion of the sheave with the ropes and the cables. So it's not far away. I'm not sure the record gives an exact distance, but it is fairly close, even though there is a different viewpoint from 1425 to 1467. I think the point here is that when you have an elevator mechanic who's working in a room that nobody goes in except for him, according to the defendant's testimony, I don't think you can compare that to the Hutchinson case that I lost in the Court of Appeals, for the simple reason that the Hutchinson case deals with an exterior sidewalk. And if you look at the record on appeal, specifically my brief, pages 3 through 7, there was very, very unusual facts in that case. That sidewalk was pristine. It was nicer than the sidewalk outside the Appellate Division. It had just been reconstructed in 2007. 5 of the defendant's employees, when they searched to look at what the plaintiff called a nut, couldn't find it after the accident. The only person who knew about it was a person named Mr. Brownstein, who was a super, who said that the only reason he knew it was there was because he was shoveling in 2011 with respect to a 2009 accident, and he felt the nut on the shovel. This is a defect that, at least at 1425, looks fairly viewable, and there's no reason to have it there. It looks like it was a remnant of a pipe. The fact that it's small, it is small, but it is right next to a dangerous instrumentality, and I would argue that the issue is one of fact for the jury. Let me talk about the ANSI regulation. It's Rule 104.1. It's dealing with guarding. 1426 of the record says, quote, in machine rooms and secondary machinery spaces, expose gears, sprockets, tape, or rope sheaves or drums of selectors, floors, controllers, or signal machines, and their driving ropes, chains, or tapes shall be guarded to protect against, quote, accidental contact. I believe that the defendant's representatives said, and this is on page 656 and page 923, that Schindler was obligated to comply with ANSI regulations. They claim that they did not know about these regulations specifically. And my adversaries point to the Bradley decision, which was a case cited in this court, affirmed by the Court of Appeals.
Go ahead, finish yours.
Can I finish? If you take a look, and I'll go over this a little more, I'm not going to go over my time. If you take a look at 157 AD 3D at 631, that decision is a complicated decision because what the court said with respect to the defect was that it wasn't noticeable. Not that this is a noticeable defect. There's no guard on part of the machine. And the reason that notice wasn't imputed in the Bradley case was because the area that caused the electrocution was actually enclosed, which we don't have here. This is a defect that's visible and seeable, and I don't think that ignorance of the law or a statement by an individual that I didn't know that something was supposed to be done because I'm not an expert exculpates them from having reasonable care. And I'll go into that a little more on my reply. I'm sorry for going over my time.
Thank you. Which respondent is going to go first? 245 East 19 Realty? Okay, fine. You have 4 minutes.
Thank you, Your Honor.
You may begin.
May it please the Court, my name is Colin Ryan, and I represent 245 East 19th Realty. And I just want to pick up on the surrounding circumstances that the appellant referenced in his argument. There's no dispute that the size of the pipe stub renders it trivial. The question is whether surrounding circumstances make it an actionable defect. The affidavit of plaintiff's expert indicated that the motor room where this incident occurred was bright and clean. Plaintiff testified during his deposition that that he could observe an area of oil spilled on the motorroom floor, indicating that the room was well lit. That's at pages 173 and 186 of the record. In addition, the photographs at 1373 and 1374 show that the pipe stub was flush with the floor, and the photos that appellant's counsel referenced at 1467 to 1469 indicate that the room was large, open, and there was nothing to distract Mr. Arpa from
Counsel, but
observing.
how far from the motor and the open sheave was this pipe stub?
I can see it as appellant's counsel did that is not clear from the record. However, the fact that there's a hoist and machinery near the pipe stub is not dispositive. The plaintiff did not allege that the movement of the machine distracted him in any way, that the ropes that are attached to the machine impeded his movement. There was nothing that would distract him.
No, I think the plaintiff is alleging that the presence of the unguarded motor portions make it more dangerous.
I think the plaintiff is alleging that the fact that he fell into the guard made his injuries more severe than they otherwise would have been. But he never alleges that the guard in any way impeded his movement throughout the
That's not what I said. I didn't say that he is alleging that it impeded it. I thought that part of the argument here was that that condition created a more dangerous condition in the area.
But there's nothing to indicate that he was distracted in any way by the proximity to the
Who
hoist.
says he's distracted? I didn't say anything about distraction.
Well, Hutchinson indicates that the plaintiff would have to be naturally distracted by the surrounding circumstances to turn a trivial defect into an actionable defect, which is why I've used that term.
But doesn't Hutchinson also say that a holding of triviality must be based on all the specific facts and circumstances of the case, not size alone?
Oh.
So the fact that this may not have been a very large protrusion is not the end-all and be-all. I mean,
I'm sorry, I didn't mean to interrupt.
he was working in this motor room, and even if he wasn't distracted, I mean, the cases don't say that, as you said, but there's a lot of things that have to be considered.
And him being alone has to be considered. He was not carrying anything in his hands. That has to be considered.
Well, he said I thought he said he was cleaning up an oil spill that he saw between the two elevator cars, and he went to throw away the rag and turned to walk back, and that's when he fell.
Right. So he had nothing in his hands. He was not distracted by anybody else in the motor room. He had been there regularly since 2014. He had been there on and off from 2005 to the present, to the date of the accident. He was familiar with the room. He was familiar with the machinery in the room. And as I said at the beginning, it was a bright and clean room. There was nothing to obstruct him from viewing the pipe stub and to distract him from seeing it when he walked through the motor room. I know my time is limited. I just want to touch on a couple of the other cases that deal with triviality, such as the Argiano case, where there's many people that would distract somebody from being able to look down and see a defect in the floor. Here, although
Go ahead, finish your sentence.
appellant's counsel referenced a jagged edge or other deformity, here there's no allegation that the pipe stub had a jagged edge, that it was irregular, or that the floor surrounding the area was irregular or deformed in any way. Thank you.
Okay, thank you. Respondent Schindler.
Please the court, Richard Sabatini, Sabatini Associates, representing respondent, third-party defendant, Schindler Elevator Corporation. I'm here to introduce Chris Bartolucci, who will argue the case on behalf of Schindler Elevator Corporation with the court's permission.
Yes, that's fine.
Thank you.
Thank you very much.
May it please the court, Chris Bartolomucci for Schindler Elevator Corporation. On the pipe stub issue, there's an important feature to the Hutchinson opinion that hasn't been discussed today, and that is the portion of the opinion in which the Court of Appeals said the relevant questions are, is the object difficult to see, to identify as a hazard, or to step over? And this part of the opinion makes clear that the surrounding circumstances, the danger that the court was talking about, are those that increase the chance of tripping, not increase the damages from tripping. And in this case, the machine did nothing to increase the probability that Mr. Arpa would trip over the de minimis pipe stub. The argument here is that the danger was magnified because after he tripped, he fell into the machine and hurt his hand very badly. But that's not the kind of surrounding circumstance the Court of Appeals was thinking about in Hutchinson. Again, we're thinking about what increased the odds of tripping, not the damages from tripping. So I would submit that plaintiff has improperly conflated liability and damages issues. Because as we know, the machine room is not a heavily traveled area. It's a locked room. Only elevator professionals and building personnel go in there. ARPA's working alone. He's not distracted from seeing the floor. He even saw the oil streak on the floor, and the lighting in the room is good. We have the additional argument in our brief.
Is there testimony in the record from any of the witnesses as to how large that room is?
Not that I recall, Your Honor. I'm sorry. We have the additional argument in our brief that Mr. Arpa's testimony is insufficient as a matter of law to establish causation because he did not see the pipe stub until after the fact when he viewed it in a photograph.
Well, if he had seen it before, maybe he wouldn't have tripped over it.
Well, but he doesn't know that he tripped on it. His testimony was, the question was, how do you know you tripped on it? Well, I tripped, and that's the only thing that's there. He testified that he never saw that pipe stub until after the fact. And under the cases we offered in our brief, that's not enough.
It's almost hidden, in other words.
Well, it's not hidden. It's in plain view. It's not difficult to observe. His testimony was he had never seen it. It's odd testimony since he'd been working in that room for a year, but that's what he said. On the motor guard issue, that issue is squarely controlled by the Bradley opinion. Bradley came out the way it did because there were no complaints and no failed inspections relating to the unguarded transformers in that case, and that maps squarely onto the facts here. There were no complaints even from ARPA himself about the unguarded shiv and ropes, and for 20 years, this machine didn't fail any inspection because of the motor guarding. So this case maps almost precisely onto Bradley, and that disposes of the motor guard issue. If the court has no other questions, thank you, Your Honors.
Thank you.
Judge Mazzarelli, I want to hammer on your point. The circumstances always do matter. They matter with negligence, and they certainly matter with trivial defects. If I put a glass of Perrier over here, it might not be a negligent act. If it's filled with hydrochloric acid, it is. And that's the point. The point here isn't that this area was open. The point is that the plaintiff's focus was on doing work. And if you look at the Hutchinson decision, which is the portion of the decision that my adversaries are relying on, it talks about the fact that this is an open sidewalk area that people pass on all the time, and for years, nobody noticed anything, nobody had a problem, the views were unobstructed. People walking on a street are not the same thing as people who are working. So I just don't see any congruency between a case where the plaintiff loses because there's an open area. The plaintiff, by the way, in Hutchinson was 67 years old. He lived in the area for 23 years. He never noticed the problem there, and he walked by there every day. And a situation where you have a room that's closed off where only workers who are only going to be doing work, who are only focusing on their work, are doing something. Plus, there's no reason to have this. And the defendant said that it was there for 20 years. If you look at your Conklin decision, which is cited in our brief, Conklin says that if you don't take action on a defect that can be considered a defect, the plaintiff can get summary judgment. I'm not suggesting that this is an intentional tort, but the defendant's assertion that they didn't believe it was defective doesn't get them summary judgment. All it does is create an issue of fact. Finally, I would just again ask you, I'm not going to go over my time.
Mr. Isaac, what is the ANSI standards? I mean, what obligation do do we have to, it's not controlling on negligence. I mean,
Right.
wasn't there a statement or an allegation in the briefs by the defendants that the court, was correct to not really consider the ANSI standards?
Yes, that's what they claim, but they're clearly wrong. The Court of Appeals, look, I lost Bradley here and I lost Bradley in the Court of Appeals, but in the Court of Appeals, I lost on the ground of lack of notice. And that's why, Judge Kapnick, I asked you to look at that specific reference in the Bradley majority decision. You know, Bradley was a 3-2 decision. What the court was talking about was notice, was they were saying that even though the plaintiff said there should be additional guards, the entire electrical unit was actually guarded. There was a cabinet, so it wouldn't be relatively obvious to someone. This case, if you look at the photos, everybody agrees that there's portions that are guarded, but portions that are wide open. And if an ANSI standard under Bradley establishes some evidence of negligence, which it does, in this case, given the testimony of the defendants themselves that they were obligated to comply with ANSI, I would suggest to you that while I might not win, as I would in a 240 subdivision 1 labor law case, at least I get to a jury and I don't lose summarily. Thanks for listening.
Thank you. Thank you all very much. Have a nice day. The next case for argument that should get ready is 1 Bryant Park versus Parmas de Lisa Cladding. Okay, counsel, good afternoon. You may proceed.
Good afternoon, Your Honors. May it please the Court, Anthony DiStefano for the plaintiff's appellants. This is actually a severed third-party action for contractual indemnification against Parmas de Lisa, and the trial court dismissed the claim on the basis that the underlying accident involving the plaintiff did not arise from Parmas de Lisa's negligence. But the contract required more than just that the accident be tied to Parmas de Lisa's negligence. It specifically said that it could be triggered by the negligence of Parmas de Lisa's subcontractor. And even more specifically, the contract said that any negligence on the part of an employee of that subcontractor would be attributed to Parmas de Lisa for the purposes of contractual indemnification. Here, the underlying jury determined that the plaintiff was, in fact, negligent. Since the plaintiff was an employee of Parmas de Lisa's subcontractor, that negligence was attributable to Parmas de Lisa.
Counsel, Tower, in addition to being a subcontractor, was also a wholly owned subsidiary of Parmas de Lisa, or am I mistaken about that?
Correct, Your Honor. That's according to the affidavit of the general counsel. So for that reason alone, the contractual indemnity claim should be reinstated against Parmas de Lisa. Now, there are two issues with regard to the extent of recovery that my clients would have against Parmas de Lisa. And the first is directly tied to the jury's verdict. Now, I should alert Your Honors to the fact that on November 12th, I will be back in the court again arguing my appeal from that verdict. But let's just assume for purposes of today's argument that the verdict is affirmed in its entirety. That verdict was as follows: 5% to the plaintiff, 90% to Tishman, and 5% to component. Right. Now, Parmas de Lisa argues, firstly, that we should not be entitled to recover for the 5% to plaintiff because that's essentially double dipping. But we're not asking to recover the 5% to the plaintiff. We understand that if we never pay that 5%, then we never have to be reimbursed for that 5%. But we were held strictly liable to the plaintiff in Labor Law 241 sub 6, which makes us responsible for the balance of his damages, which are 95%. With 90% being attributable to us and 5% to another contractor, Component Assembly Systems, to the extent that we pay for components 5%, we could either recover that from component directly in contribution, or we could recover that from Parmas de Lisa in contractual indemnity. The second part of it is that no jury has ever decided the issue of Parmas de Lisa's negligence. And here, what we have are questions of fact that remain on that issue, because we have a contract, and we have a contract provisions that specifically require Permis Lisa to be responsible for its work areas, to be responsible for the safety of the employees of its subcontractor. And specifically, it says that Permis Lisa has to have a designated safety representative on site at all times when it's doing its work. And in this case, the plaintiff actually testifies that the designated safety representative for Permis Lisa is his father. Now, he cannot testify to what his father's responsibilities are, and he cannot confirm for sure that his father was on the project on the day of the accident. But when you take that testimony in conjunction with the contractual requirements for safety that are imposed upon Permis Lisa, those are issues of negligence. And because no jury has ever been asked to decide those issues, we cannot be stopped from raising them once we have more discovery on the issue, because this was a pre-discovery motion that was made by Permis Lisa. So we have no depositions. We have not taken the deposition of the father, so we don't know the extent of his responsibilities. So to that extent, once the claim is reinstated against Permis Lisa, we would ask that it be remanded back to the trial court for further discovery on the issue of Permis Lisa's negligence. And unless the court has any other questions, I'll rest on my brief. Thank you.
Thank you very much.
Good afternoon, Your Honors. May it please the court. Adrian Yaron, Cullen and Dykeman for Permis Lisa. Your Honors, this is a case that exemplifies the old adage, choices have consequences. Appellate chose not to try this case against the empty seat of my client, Permis Lisa, and not to ask the jury to apportion any liability to it. The appellate should be stopped from trying to claim it here. 90%, the jury apportioned 90% of the liability to appellants, and it apportioned it not based on Labor Law 241, but based on their own negligence. This court, in the appeal from the summary judgment motion and the underlying action, which can be found on page 196 of the record, held this is a premises condition case, not a means and methods of the workers case.
Counsel, wasn't Permis Lisa severed? I mean, they started, there was a third-party action that was severed from the main action, correct?
Yes, Your Honor, but that
And,
doesn't
and,
prevent...
and when this matter went to trial, it was only the main action that went to trial, and Permis Lisa was not a party anymore, correct?
Correct, but that doesn't prevent appellants who were in the main trial from trying the case against the empty chair. I've done it myself in trials. You say, this other guy who's not here for whatever reason, he's the one that did it. You can make that choice to try that person, and I mean, it wouldn't be binding on my client, but it wouldn't have precluded him from now seeking that. He didn't do that. Appellants didn't do that. They instead went to trial without mentioning my client, without trying to have anything apportioned to them, and everything was apportioned to appellants. 90% of the negligence in this case.
What prevents the plaintiff from now proceeding against Permis Lisa in this action and trying to establish if there is any negligence on his part?
The jury found that appellants were negligent and liable for 90% of the finding. That's 100% of what the jury found against them was found because of their own negligence.
What about the
The general
5%?
obligations law prevents them from getting indemnity for their own negligence.
What about the 5% that McCullough, which was the plaintiff in the main action, who was the employee of Tower, which is a wholly owned subsidiary of Permis Lisa, what about that 5% negligence?
That's
Wouldn't that
not
be
part of the
imputed?
verdict.
Wouldn't that be imputed?
That was contributory negligence. It wasn't part of the verdict that appellants are liable for. So what is there to indemnify? And that's exactly what the trial court held. Ultimately, this is a premises negligence case. The appellants are the owner and the general contractor. This court held in its previous decision that the appellants and the general contractor are liable for the premises, the safety of the premises, that the constructive notice is attributable to them, and the jury also held that it was their responsibility and they were negligent 90%. It's not a 241 case, it's a negligence case. The jury was specifically asked if they were negligent and violated Labor Law 200, which is statutory negligence, and the jury so found. So the general obligations law precludes them from now trying to obtain indemnity from my client. One last thing, this case was severed in 2016. The other choice that appellants made was not to pursue discovery in either the main action or this action until long after trial. In fact, they still haven't tried to pursue it. So any comments about not being able to get the deposition of the father or whatnot is, again, that's a choice that appellants made. And those choices have consequences. They have collateral estoppel against them. They have, all the negligence in this case was found by the jury against them. They are, and they really have no entitlement to, they could have had all the discovery they wanted, and they didn't get it. The general obligations law precludes them from indemnity against my client. By the way, in that appeal that's coming up, they haven't even appealed the negligence finding against Tishman.
Okay, thank you very much. Thank you both, counsel.
Thank you, Your Honors.
Have a nice afternoon. The next case for argument is McGowan versus Clarion Partners. Good afternoon. You may proceed.
Good afternoon, Your Honors, and may it please the Court. I would like to start by saying I really do thank you from the bottom of my firm, thanks you from the bottom of our hearts for your public service and offering in-person oral argument. I think it's a testament to the Court's public service, and it's very much appreciated.
Thank you.
This case does not involve the technical issue of a term sheet. This case involves a very important public policy of New York law that's been the law for decades and decades, which is that if sophisticated parties reach agreement on essential terms, the fact that they contemplate more detailed documentation does not in itself in any way preclude a binding agreement. And
Were all of the terms here agreed upon?
yes, Your Honor. In this case, you had the exact dollar amount of the investment, you had the exact percentage of equity that the investors would get in the new entity, and you had words and deeds and internal emails which were produced in discovery from the opposing party, which made absolutely clear that not only was Class A shares the contemplated form of equity, but the Clarion Partners executives, a few days after the agreement was reached, admitted and used words like he hated the idea that we were changing from Class A shares. He hated it. There's internal emails that admit this.
Well, hating a change isn't the same as breaching a provision that's already been agreed to.
I'm sorry, Your Honor?
You're saying he said he hated the change.
But what I'm saying, Your Honor, is that as of the date of that term sheet, there are internal emails which demonstrate irrefutably that the parties were all talking about and understood that Class A shares were the form of the equity. And I will say this, that is a detail. I'd like you to consider this example. Imagine 3 people invest in a restaurant. Each investor puts in $1 million. We agree on a term sheet. We each own 1/3. And we say the detail, the form of the company will be determined. And we debate between an LLC and a subchapter, a corporation that's a subchapter S for tax purposes. And we leave that detail open, but we agree on the percentage of the ownership.
What if you also in that agreement specified the chefs and the sous chefs, and then right before or right after the agreement is entered into, the sous chef and the chef say, hey, I'm staying with the restaurant I'm with now, which is what happened here with Kekala and the other fellow whose name escapes me, Mr. Winkle.
Well, Your Honor, respectfully, the term sheet, and that's a fair question, but in this case, the term sheet specifically contemplated that there might not be the 3 members of the management team that were specified in the term sheet. It expressly contemplated that. It specifically said, and hold on one second, I just want to get that record set. The agreement, the term sheet specifically said that if not all, here it is. Okay.
But what about the fact that this particular term sheet said that this was a preliminary agreement contingent on and not intended to be binding absent formal documentation? So they knew.
Where does it say that?
I mean, they agreed that it was not to be binding. They actually put that into the terms of the term sheet. So isn't that a problem?
No, Your Honor, respectfully, the phrase that was used is agreed amongst the parties, but subject to signed documentations. And in all of the cases we cited, the courts over and over again said that the mere fact that you expressly contemplate additional agreements or more formalized agreements does not in itself preclude a finding that an agreement exists. So, for example, in this court,
excuse me.
this is completely indistinguishable from this court's decision in Bed Bath & Beyond.
Excuse me, I thought the term sheet also said that the structure of the economic interest is to be determined. Isn't that very basic?
The term sheet used the phrase that the structure was to be determined, but there is contemporaneous evidence that what the parties all discussed was Class A shares. And there's a second important point, Your Honor. If that, even assuming arguendo that that was a material term that was left open, which we dispute, we contend that by the time the parties had this term sheet, the evidence in the emails indicate that the parties all agreed it was Class A shares. So we contend that there's at least an issue of fact as to whether the Class A shares had been understood. But even if the court took a different view and said as a matter of law, no trier of fact could find that those internal emails discussed Class A shares. Let's assume that. In the very least, the parties had an obligation to negotiate the one term that was left open in good faith. And in this case, the internal emails prove that when a few days later, after the term sheet was signed, they reneged on the basic investment, which was in dollars. The other side changed it to euros, which was a 30% difference. And under this court's precedent, if you fundamentally change one of the agreed to terms, as you're trying to negotiate the one last open detail, that violates the covenant of good faith. Otherwise, term sheets mean nothing. If you have a term sheet that sets forth 5 out of 6 issues and leaves 1 to negotiate and then allows parties to come back the next day and say, well, let's redo the whole thing, that makes commerce in New York impossible, because when deal makers go into a conference room, they need to be able to put the terms and know that it means something. Otherwise, under this precedent, parties can just get out of an agreement by saying, well, we left one issue open for discussion, and then actually contradict the ones they already agreed to.
Okay,
and that's a dangerous precedent for New York law, because New York law is at the centerpiece of economic vitality, where deal makers need in a few days to be able to negotiate a deal and then leave it to the lawyers.
Counsel, you'll have 3 minutes for rebuttal. I think
Thank you, Your
we
Honor.
got your points there.
Thank you, Your Honor.
Thank you very much. We'll hear from the respondent now.
Can you answer the question that I think counsel was about to answer regarding,
I'm having a hard time understanding you.
Yeah, I have, I'm sorry, Your Honor, what would you like me to answer?
well, basically, the day after the agreement was signed, one of the parties said, I want out, right? I don't know if it was Winkle or Cashel, said, I want out.
That is,
So does that undo the agreement?
you're right. On the Monday following the signing of the term sheet, you're absolutely right. One of the signatories, Mr. Winkle, sent an email back to Mr. Ferneri of Clarion and said, I reject your offer. He didn't even say I want out of the contract because there was no binding contract. He said, I reject your offer. And he was deposed and was asked the question, did you ever view this as binding upon you? And he said, of course I did not. In no way was it binding on me, and he was a signatory to the agreement.
So my next question is, if the three of them are considered to be the management team, I believe that that's because your client wanted them, all three, to be together, right? In order for this thing to go through, this deal to go through.
Yes, Your Honor.
So now he's out.
The expectation was that they were going to be a team. You see all throughout the term sheet the term management team, management team. One of them, Mr. Kakel, there may have been a slight delay in him joining because he was still under contract with his employer, but that was not the case for Mr. Winkle, who was to join right away, and then he backed out. So this was all about the management team. In the court below, they tried to minimize that, but this really, from Clarion's perspective, with the prospect of a new venture, they wanted the entire team, that's for sure. And the evidence here, let me just go back to the term sheet itself because Your Honors are correct. It expressly says, agreed to amongst the parties, but subject to documentations. And why it's subject to signed documentations, courts, there's a long line of cases that Your Honors are familiar with that hold language like that expresses an intent not to be bound, and that is contingent upon signed documentations, and
Does
that
it
makes
matter what issues are left open, how significant, how material they are in making the determination as to whether or not it should be considered a binding contract?
Possibly, but that's actually an independent reason why this term sheet was not binding as well, because of the material term about the economic interest, which states right in the term sheet that is to be determined. And so that was not agreed upon at all. But putting that aside for a moment, the language alone, subject to signed documentations, means something. Mr. McGowan reads that out of the term sheet. There is a long line of cases we cite in our brief, Westinghouse, Luxor Capital, Offutt, Missigman, so on and so forth, that say when parties express language like that, it is an intent not to be bound. Now, there are certain very narrow exceptions to that, and you see that in the auction bid cases, for example, in the Stonehill case and the Emigrant case, where in an auction bid context, for example, the bidders come into it knowing that their bid, if accepted, it is binding. And so simply because the bid sheet says subject to final documentations, that doesn't mean the bid's not binding. And in Bed Bath & Beyond, what you had there, you had partial performance, and you had a contract that expressly authorized the parties to go ahead and perform, and they did. And so just because you had subject to there, that doesn't mean in that context that they didn't have a binding contract. This case, not only was the term sheet itself not binding, but the evidence is overwhelmingly shows that it was not binding. And you have Winkle backing out, you have even Mr. McGowan himself looking at what he said contemporaneously over that weekend. When Winkle backed out, Mr. McGowan says, well, he had a case of the yips. He said, Germans are not adaptable. He said, let's do a postmortem and see where we were. He then spent the next 2 months chasing down Mr. Ferneri, and Clarion treated him with the utmost respect and good faith. They tried to find even a consulting position for him. They thought about that. They said, maybe you can be a capital raiser, and he just would not relent. And we're talking about policy. We have a policy here of not letting opportunistic litigants entrap others into contracts they never intended. It's also worth pointing out there were absolutely no lawyers involved with this. It was a preliminary discussion in a conference room. It has all the hallmarks and indicia of something that is not binding. As to the implied contract of good faith, or of one, there was no good faith obligation because there is no binding contract, but at all times, he was treated in absolute good faith by Clarion for sure. And another thing worth just pointing out is in May, 2 months after this, sort of out of the blue, Mr. McGowan had his lawyer in Germany send these draft articles of association to King & Spalding, my law firm in Germany. And Clarion said, well, what are you doing? We have no idea what this is. But even those draft articles of association show what all these other documentations were that would have had to have been agreed upon: operating agreements, formation agreements, articles of association, and even those weren't even agreed upon. If the panel has no further, and finally the promissory estoppel, there was no unequivocal promise, there's no reasonable reliance. The lower court got this entirely correct.
Thank you, counsel.
Your Honors, thank you very much again. Couple of very important points I'd like to stress. First, with respect to the fact that Mr. Winkle decided not to go forward, there are two very important points. First of all, on page 223 of the record, the term sheet itself, it was specifically contemplated that, quote, such amounts will be allocated per person and the gross amount adjusted if there are less than 3 management team members. Now, again, if sophisticated parties enter into a term sheet with the material terms and specifically in the plain text contemplate that not all 3 of the members will be as part of the team, that possibility exists, it defies logic and policy of New York law to say that if one of them decides to not go forward, that there's not a binding agreement, because Clarion understood that possibility existed. It was part of the agreement. So that's fundamentally, with respect to the lower court, that's just incorrect. And secondly, what's very important is that that person's decision to not go forward came after Clarion already reneged on what was agreed, which was that there was $1 million in US dollars. And Clarion does not dispute, and you heard counsel, he does not dispute that they did that switcheroo, that major switcheroo happened. There was an agreement on $1 million, and they immediately tried to retrade. And when Winkle heard that, he got upset. He already had a job, and he went to his other job, and they offered him more. Because he said, let me get the heck out of here. These guys just retraded. I should be able to argue that to the jury.
Mr. Winkle was deposed, correct?
What's that?
Mr. Winkle was deposed? He was deposed in this litigation?
Was he deposed?
He was deposed.
And did he answer exactly what you just said?
What he said was he acknowledged that there was this discussion about the euros, and he testified that after that happened, he decided that he was going to go do his own thing. But the fact of the matter is, it's a question of fact for the jury at trial, that if Clarion Partners switches the $1 million to make it 1/3 higher and says, well, you know what, I'm going to stay at my other job, and he negotiates a higher salary, the term sheet contemplated that might happen. So there are many fact questions here that are just not fair as a matter of summary judgment for Mr. McGowan to not have a trier of fact look at the evidence, including the contemporaneous evidence that Class A shares was specifically not only discussed, but the internal emails from Clarion
make very clear that they themselves consider it a retrade. If you look at page 234 of the record, there's a very clear statement that this is a retrade. On page 524 of the record, he says, he hated the idea of putting euros in the European business. He asked, did Barry balk at any of the new terms? This is on March 11th, record page 524. If a jury can't hear that to understand that there was an agreement, then what this court is saying is that a term sheet is meaningless. If there's any detail that needs to be ironed out later, the wolf can just walk away and just say, well, I want to rediscuss what we already agreed on.
Right,
And that's not good for
Counsel,
public
can you
policy.
just finish up, because you're over your time, okay?
And Your Honors, I will say that, in closing, that the other causes of action, clearly, in the least, there are issues of fact, because in the very least, there was an issue of fact as to whether, if there was a detail left, that should have been negotiated in good faith. And the opposing counsel argued that you only have that duty if you have a binding agreement. That gets the law completely backwards. The law is absolutely clear that you can have a preliminary agreement to agree, leaving a material term open, and you still have to negotiate that material term in good faith. It's completely incorrect to say that you need a binding agreement to have that duty of good
Okay,
faith.
we will look again at your briefs. Thank you both
Thank you very much,
for
Your
the
Honors, again, for your
arguments.
public service. Thank you.
Have a good afternoon. Thank you. The next case will be Cortez versus Ventura.
Arlene. People touch it.
What? Oh, okay. Oh, I see what you're saying. Okay, counsel, good afternoon. You may proceed.
Thank you, Your Honor. My name is Thomas Torto. I represent the plaintiff appellant on this appeal. May it please the court. It's our position that the plaintiff made out a prima facie case of entitlement to summary judgment on liability by showing that the plaintiff had the right of way in proceeding on 37th Avenue, and that the plaintiff was entitled to assume that the defendant would obey the command of the stop sign.
But let me interrupt you, Mr. Torto. Didn't the defendant, first of all, there were no depositions in this case. This motion was made pretty early along, but didn't the defendant put in a statement that we know he had a stop sign. He stopped, he said 30 to 40 seconds at a stop line, at the stop sign. Then he inched up very slowly, looked both ways. He didn't see anybody coming. So then he went into the roadway, and only as he was pretty much through the roadway did plaintiff hit him in the back, which is where the damages seem to have been. How does that prove that the defendant is negligent? Isn't there an issue of fact at this stage as to what really happened there?
Well, we'd ask the court to consider the layout of the intersection,
I looked, yeah.
which is a sharp diagonal intersection where 110th Street intersects with 37th Avenue at a sharp angle. And that would explain the plaintiff's car coming in contact with the rear of the truck. Because if you look at the other version is that the defendant stopped and obeyed the stop sign, but then he didn't yield the right-of-way.
But he says he said he never saw, now I don't know what happened, but the defendant, at least what we have before us, is that the defendant said he did stop, he did look, and he got into the intersection, And then the plaintiff must have come out of nowhere. He didn't see the plaintiff, but he said he looked.
Right, none of the cases that we cite, that's not enough to raise a question of fact. The defendant argues, quote, "There is no telling where the Cortez vehicle came from or what speed he had been traveling at." In view of that concession, he doesn't raise a question of fact as to the plaintiff speeding, as to the plaintiff not having the right of way. No matter how you look at this,
Counsel, one case you don't really grapple with that the defendant cites is Navarez. And in Navarez, you had a similar situation of a perpendicular intersection with one way being controlled by some kind of traffic control device, I don't recall what kind, and the other one not being controlled by it. And in Navarez, it was found that dueling affidavits like the ones we have here was sufficient to create an issue of triable fact. So do you want to talk about Navarez a little bit now and differentiate it?
I thought Navarez was where the plaintiff was, the issue was whether or not the plaintiff was in a crosswalk.
Okay, well, what do you want to say about Navarez?
Which I think is factually distinguishable. This is a two-car collision. So, I mean, and I think where the Supreme Court erred is that it concluded that the plaintiff struck the defendant's vehicle in the rear while the defendant's vehicle was making a right-hand turn on the 37th Avenue. That's not what happened at all. And furthermore, I'd ask the court to consider our argument that under Rodriguez, plaintiff's entitled to summary judgment, and the issue of comparative would be decided later on. Unless the court has any questions, I'll rest on my brief.
Thank you, Mr. Torda.
Thank you.
Good afternoon. May it please the court. Firstly, thank you for allowing me leave application to argue today and granting my late application. Your Honors, the question primarily is who had the right of way in this intersection. And that is what I believe a jury is going to be confronted with, or should be confronted with, in determining whether or not Mr. Ventura was negligent at all. Counsel cites to Rodriguez, the city of New York, which I understand. If there's an issue of comparative fault, which they're looking to dismiss, by the way, then I do concede that comparative fault would not prevent summary judgment.
But we have to have, I mean, this says that if there's negligence on the defendant's side, we're allowed to find that without dealing with the issue of plaintiff's fault. I understand that. The question is, do you think that there is an issue of fact as to whether or not your client was actually, is there a way to explain what happened without your client necessarily being negligent?
Okay. Justice Moulton brought up the case of Narvaez, and I believe it was Justice Mazzarelli who sat on that bench and concurred with the majority. Those circumstances are very, very much like the circumstances here. In fact, I think this is even better. In Narvaez, the car that had the through street had hit the other vehicle broadside. In our case, we have Mr. Cortez, who had made it to the far lane. He was almost completely on the other side of the road, and he was clipped at the tailgate, as the photograph that Mr. Ventura had attested to. That's where the point of impact was. So I believe that, Your Honor, to answer Justice Kapnick's question, yeah, there's a question of fact as to whether the sole proximate cause of this accident was Mr. Cortez in not honoring and going into an intersection where Mr. Ventura had looked both ways, entered the intersection, was almost on the other side of the road, and he gets clipped by Mr. Cortez. I would also offer this, Your Honors. The statute governing stop signs does not provide, there's no conclusive presumption of fault just because you have a stop sign. And under the circumstances of this case, we ask this court to deny the appeal in its totality. In addition to that, though, this is very early on in the litigation. the plaintiff's own passenger, the passenger in Mr. Cortez's car, has also brought suit against Mr. Cortez, alleging that he's negligent, the passenger who saw what happened. So there's lots of questions of fact here. If there are any more questions, I'll rest on my brief at this point.
Okay, thank you both very much.
you,
Appreciate
Anna.
you coming in today. The next case for argument is CHA Design. I believe just the appellant is here for that case, correct? Okay. You may proceed.
May it please the court, my name is Matthew Canini of the law firm of Sills, Cummins & Gross. I'm here representing appellant Alan Miller. The core issue here is whether a corporate officer can be held liable in tortious interference with contract for causing his company to stop paying the invoices of respondent because he paid another creditor.
Well, the complaint also alleges that he was also enriched in not very specific ways. One way that's mentioned is that he avoided down the line having to pay on a personal guarantee. So doesn't that differentiate this case from your average rule?
So, Your Honor, basically, in order to hold a corporate officer liable, respondent had to plead with particularity that appellant's decision to stop paying respondent was motivated by his personal gain as distinguished from the gain to the corporation.
Well, wasn't there a claim in this complaint that the defendant sort of dragged the plaintiff along or towed him along a little bit, and then he found himself another job? So that was for his own personal gain.
So, Your Honor, it is not enough, as the opposition contends, that that basically there is some benefit to Mr. Miller. The personal gain has to be distinguished from a gain to the corporation, and the primary motivating intent must be malice. The only particularized allegations on this complaint as to personal gain is that Mr. Miller kept his company afloat from 2011 to 2014. And during this time, it is undisputed that respondent received periodic payments from Mr. Miller. It simply is not tortious for Mr. Miller to have kept his company afloat and during that time for him to have stayed employed with his company.
But it would have been inappropriate for him to use money for his own personal gain, for his own personal expenses, which is at least what is alleged at this 3211 stage of the case.
So Your Honor, so the lower court did sustain this complaint based on the allegation in paragraph 15 of the complaint. And I quote, "Instead of using the revenues to make the agreed payments to plaintiff, Miller and or the other developers used them to pay himself directly and or indirectly." There is a very strong public policy in this state against holding a corporate officer liable for breaching the contracts of the corporation. Owing to this is a heightened pleading standard, and a single speculative and or allegation should not be sufficient to sustain a claim. Critically, there is no allegation in here that these payments or this indirect benefit to Mr. Miller was in any way wrongful.
This is a pleading motion.
Yes, Your Honor, this is a pleading motion.
At this point, how is the plaintiff supposed to be in possession of all of these facts to satisfy this heightened pleading standard?
So, Your Honor, this is an intentional tort. He had to have intentionally interfered with the contract for the purpose of breaching it for his own personal enrichment. Owing to that very strong New York public policy, plaintiff must be able to come forward with at least a reasonable amount of facts to identify what conduct tortiously interfered with that. Here we have a speculative allegation of nondescript payments to Mr. Miller, and the allegation seems to be, well, you didn't pay my company, so you must have paid yourself. Or the allegation seems to be that, well, your commercial factor, another legitimate creditor, shut down your business, so you must have paid them instead of paying me. You know, this is an unsecured creditor. There is no creditor preference here. It is the law of this circuit since the Ultramar case in 1990, this department, since the Ultramar case in 1993, that paying one creditor versus another creditor is not in any way improper. To the extent that Mr. Miller received some incidental benefit by paying one creditor versus another creditor in the form of lower potential liability on a personal guarantee, that is incident to the lawful and commercially reasonable act.
I mean, I have the complaint in front of me, and he does argue in more than just paragraph 15, the plaintiff does, that Mr. Miller used this to pay for other benefits he personally received, and that he kept the company afloat just until he could find new employment for himself. I don't know if you're saying that that's not enough.
So, but to that point also critically, there is no allegation here that those payments were wrongful. Absent such an allegation on a heightened pleading standard, there could be any number of corporate benefits that are completely innocuous, such as salary. You know, the only particularized allegation here as to what Mr. Miller's intent was, the only allegation that is not he tried to achieve some personal benefit, is that he acted specifically to keep his company in business. It is not improper for a corporate officer to draw a salary or any number of corporate benefits such as health insurance while he's keeping his company afloat. You know, what will discovery in this case ostensibly look like? You know, plaintiff will presumably be seeking to plumb the entire transaction history of the company, looking for some direct and or indirect benefit to Mr. Miller, simply on a heightened pleading standard to protect the corporate form and protect a corporate officer's right to make decisions about which creditors to pay. It should not be the case that they can do that based on a single speculative allegation, and an allegation which, as a matter of law, is insufficient to sustain the complaint because he can pick winners and losers in terms of creditors.
Okay. We'll take another look at your brief. Thank you very much for coming in today.
Thank you very much.
Thank you. The next case to come up is Broer versus Lepore. Okay, good afternoon, counsel. You may proceed.
Good afternoon. May it please the court, my name is Jim Perkins of the law firm Greenberg Charig on behalf of Dr. Broer. A central question to be decided and looked at on this appeal that runs through virtually all issues on appeal is the question of whether members of a business company can charge personal expenses to that company and characterize them as compensation or ordinary and necessary business expenses. We say that they may not, and that the fact in this case that the members did that, particularly Dr. Lepore, that was a breach of their duties, and that it violated the operating agreement and federal tax law. Now, as concerns derivative standing, the lower court dismissed the derivative claims against that my client had brought on the basis of standing. As concerns derivative standing, that question in itself demonstrated a reasonable doubt that the members who investigated my client's demand had acted in good faith. Under the case law, when a decision is taken that shows a reckless disregard as to what will happen to the company, that is an indicia of bad faith, and at least, which is the pleading standard, that there is a reasonable doubt that the members that had investigated had acted in good faith. Now, the lower court concluded that all Dr. Brower complained about, all the pleading showed, was complaints about motivations and the end result. And we submit that that is not so, that the record is replete, and the pleading is replete with allegations casting a reasonable doubt that the members had acted in good faith.
So can you point to those allegations actually in your complaint?
Well, I will. I'll summarize them, because in addition to the pleading itself, there were affidavits that were submitted by Dr. Brower and by his wife, who had formerly acted as the accountant to this company back in 2005. And the facts and the allegations show that in addition to that conclusion, that although the two members who had conducted apparently this investigation had claimed they had hired DLA Piper to what they say was to lead the investigation along with an accounting firm that they hired, there is no report of DLA Piper. There is no report of the accounting firm. The only thing that there is are draft schedules. And those draft schedules are not explained. There are no conclusions drawn. They're indicated to be in draft, and in the margins of those schedules, it states comments of Jay Arnold. Jay Arnold is one of the members who made the decision, the ultimate decision, that they would not go forward and prosecute the claims that Dr. Brower wanted to be done. There is a report, or there's a letter from litigation counsel that dated November 15th that purports to summarize exactly what happened. And what that report states is that the disinterested directors or members reached a conclusion that it is true that Dr. Lepore had overcharged, and therefore subject to a calculation, that he in fact was owed money after that calculation.
And that the charges were part of his compensation too. Wasn't that the point made in the November letter?
That's correct. And the statement, the number of statements that are made is that these personal expenses, and there is an admission that these were personal expenses.
And did your client ever see the underlying work by the forensic accountant?
What we saw were these October 20 schedules that, again, are in draft. They're not signed by the accountant.
Right.
There's no, again, no audit letter or no concluding letter of the accountants. So there's no indication it was in draft. It was not in final. So that's certainly a mystery as to what happened with those. The other aspect of this is the result that they obtained. And again, it is not the ultimate result, but how they got there. And how they get there is they claimed that there was a sharing ratio in the operating agreement that allowed a calculation of these personal expenses to conclude that certain of the personal expenses were overcharges and other of the personal expenses were okay. The only problem with that is that the sharing ratio refers to business expenses. These are business expenses. We cite a number of cases in our briefing that says you may not. This is almost tax law 101. You may not run personal expenses through a business company.
Right. So a bat mitzvah would not be a business expense.
That is correct. Nor would family ski vacations, nor anything along those lines could they possibly be deemed to be business expenses. The other thing that they did to soften the blow of exactly what was going on here is they awarded retroactively $35,000 per year for 7 years to Dr. Lepore to apply that to this calculation and say, oh, by the way, we owe him money. The only problem with that is that $35,000 was also supposed to go to my client. And it was supposed to be a decision.
Your client was also found to have to have spent some of these expenses, right?
He
And that
is
he owed the company.
alleged to have spent. And what he says, and this is in his affidavit, is that there was an agreement you could charge home office expenses, that he did that, and that if he is in the final accounting, there's an accounting claim here.
And that claim, the Judge Sherwood left in the case, right?
Correct. And he says if he's found to be responsible, that he will pay those charges. But he fundamentally disagrees that you can charge personal expenses through a business company. The other issue I want to touch on, because I'm close to out of time, is that we cross-moved for summary judgment on this question. We have a declaration that says this is improper, it should not be permitted. This is important because in Dr. Lepore's affidavit, he says this conduct is going to continue. That jeopardizes my client as a 20% shareholder. We believe that that was a question of law that should have been decided. It even could have been decided without a cross motion, but we cross-moved. The judge concluded, because issue had not been joined, that he would not decide it. Once issue was joined, we moved to renew. And he said that that renewal is not a new fact that allows you to renew. We cite 2 cases from this court that says that's not so, and then a third case called Ramos, which held as a result of a reversal of a conviction, it was okay to renew. That was a new fact. And that's exactly what this jointer of issue was, where the court should have granted judgment on that question to stop this misbehavior.
Okay, Mr. Perkins, you'll have 2 minutes for rebuttal, okay?
Thank you.
You're very welcome. Which one of the respondents wants to speak first? For counsel, let you choose.
Thank you, Your Honor. Andrew Margulies on behalf of respondents, Med Reviews, Mr. Arnold, and Mr. Black. The fundamental issue here that Mr. Brower didn't really address in detail is the right of a shareholder to bring a derivative action. And what happened here is that Dr. Brower made a demand on the company to investigate the charges made by Dr. Lepore. At the time, he knew there were only 5 members of the company. Dr. Brower was one, Dr. Lepore was one, and Dr. Lepore's brother was the other one. He knew the only 2 people left to do the investigation would be Mr. Arnold and Mr. Black. And by making a demand on the company, he conceded that they were independent and non-conflicted. Less than 60 days later, he filed suit, knowing the investigation was still going on. Dr. Brower had no right to bring these derivative claims, as the lower court properly found. The only time a shareholder can bring a derivative claim is if a demand was wrongfully refused. The demand here was not only not wrongfully refused, it wasn't refused at all. The demand simply said to the company, I demand that you investigate and recover money from Dr. Lepore. The investigation was conducted, and the company hired DLA Piper as counsel, who then hired a forensic accountant. They performed the examination, they assembled the schedules of all the charges going back for 10 years of what was spent by both Dr. Brower and Dr. Lepore, and concluded that Dr. Lepore, in fact, owed the company money.
What was shared with Dr. Brower besides the November letter and the draft schedules?
I submit they were not draft schedules. He might have forgotten to take in the word draft. They were extensive schedules as to all the charges year by year, as to every charge that they made. The way they made charges is that they both had company credit cards. So he went through every credit card charge from 2006 to 2016, assembled them, put them in form, put them in the schedules, got information about what they were for, looked at the backup, and that was all given to Dr. Brower. Dr. Brower was also given access to the company's QuickBook financial records, and he had access to the entire financial record system at his request. Based on a Delaware corporate demand, he was given access to the QuickBooks. So he had all that information. Now, when Dr. Brower said that he had specific allegations, and Your Honor asked him what those allegations were, here are the allegations that he even puts in his brief. The first one was that Mr. Arnold had every motivation to protect himself because of his employer, Dr. Lepore. Well, that's contradicted by the complaint, because the complaint shows that the company and Mr. Arnold found that Dr. Lepore, in fact, owed money and took steps to recover it. So whatever the motivation was, he wasn't indebted to Dr. Lepore because he found Dr. Lepore owed money. He complained about the amount that they found Dr. Lepore owed. Again, that's a conclusion. He talked about failing to address other charges. The demand was only that Dr. Lepore made improper charges and the money should be recovered from Dr. Lepore. That was the sole statement in the demand, and that's what they investigated.
So what would be Dr. Broer's path? What could he have done if not brought this derivative action? Could he have, in some other way, was there an arbitration provision if you're not happy with what the investigation shows? Was there anything like
His
that?
mechanism was exactly what he did, make a demand on the company and ask the company to take action.
But what's the okay, then if you're not happy with the action, then...
Well, you can't. They're protected by the business judgment rule. If you make a demand on the company, this is a derivative claim, not a direct claim. If you want to bring a derivative claim, it only can be if the company wrongfully refuses demand. Any decisions the company made are protected by the business judgment rule. He doesn't like the fact that they found Dr. Lepore only owed X instead of Y. They're protected by the business judgment rule.
They're only protected by the business judgment rule if they're in good faith and there's no conflict.
But there's no allegations that they acted in bad faith. They hired DLA Piper. They hired a forensic accountant. They looked through every charge of the company for 10 years, made conclusions as to what the agreement provided. And also, as Dr. Brower said, he made charges too. So they looked at the company history. Dr. Brower said he's allowed to have a home office. He spent tens of thousands of dollars on Amazon.com and Costco and spent $140,000 of the company money to pay his personal income taxes. So that was all taken into account as to what the agreement of these partners was about how they were going to spend the money. It would make no sense to have an agreement that says only business expenses can be spent by the partners, but have it in a section called compensation. Reimbursement for a business expense is not compensation. Companies are allowed to give their members fringe benefits, such as we'll give you $500 a month for a car. That's compensation, and that's okay, even if
But
it's a
you
personal
can't pay
expense,
for
as long as
personal social expenses.
Excuse me?
You can't pay for personal social expenses.
You can if the company allows you to, as long as you declare them as income. They can be income, but a company can say to its owners, we'll allow you a certain amount, which is why you have a sharing ratio. It makes no sense to spend how much you can spend based on your ownership of the company if it's a legitimate business expense. If it's a legitimate business expense, it shouldn't be capped.
Okay,
I see my time is up, and I'll rest on my brief unless there's any other questions.
thank you very much.
Thank you, Your Honors.
Now, counsel for Dr. Lepore.
Yes. If it may please the court, my name is Matthew Tracy of Wingate, Spatafor, and Schwartzberg, counsel for Dr. Lepore. And just following up on co-counsel.
You also have a cross appeal on...
Yes, I do, and that'll be related.
On the
I will-
fraud claims,
I
okay.
figured it made sense, and I'll combine the two, and I will just incorporate a lot of co-counsel's arguments in terms of the derivative
Sure,
claims, and I
thank
figured I
you.
would get right to my claim. And it's related, is if you look in the complaint and the documents, in December of 2009, my client specifically referenced in an email to Dr. Brower that there was a $50,000 spending account. There was no attempt to hide this from Dr. Brower. This was, as you saw, Dr. Brower was spending tens of thousands of dollars on his own expenses. This was known to everybody. And so Dr. Lepore, takes exception to that, and the documents back up Dr. Lepore's version of events. Importantly, for example, and this is now relating to my appeal, we have been sued for fraud in connection with a 2009 sale of stock in which Dr. Lepore purchased 23% of stock from Dr. Brower. And in doing so, Dr. Brower says, well, you did not disclose that you were charging personal expenses to the company. And we've seen, you can look at the December 2009 email talking about the spending account. But more interestingly is there is in the complaint, you'll see at paragraph 34, that there's a lot of talk about Dr. Lepore charging his nanny, putting her on the payroll, and without the consent of the company or Dr. Brower, and that is just not supported within the record itself. I point you to page 414 of the record, and you will see what that is an enclosure from Anthony Mongelli, who was the accountant, who is giving the various documents and various financial information. One of them is that Eva, who was the quote-unquote nanny in question, was being on the payroll as an admin, making $36,000 a year. Dr. Brower knew this and was on notice of this as of July of 2009. Judge Sherwood said there wasn't enough specificity, and we think he was wrong with that, because for that particular expense accounts for approximately $287,000 of what they're complaining about. They complain about $1.485 million, and of that, the putting Eva, and I'll just say Eva because her last name is, I'll not account right now. I see I am running out of time, and I will talk.
You have 2
minutes. Is that that Eva's expenses or her payroll was a huge part of what the overall spending was. In fact, other than the credit card expenses, this was the largest single annual expense. It ran anywhere from $36,000 to $400 a year from 2006 through 2014. And Dr. Brower knew about this in July of 2009, 6 months before the sale of the stock went through. And getting back to dismissing the complaint is, again, in terms of misrepresentation, there is absolutely no specificity on what exactly was misrepresented to him. It seems to be they've almost abandoned that or are trying more to argue a fraudulent concealment, that we were holding back, or Dr. Laporte was holding back financial information, and it turns out that's not true. That this is just one example of, again, transparency and letting two partners, one partner knowing what is the documents and what is the financial situation of the company. And this is in 2009. That would result in dismissal of the direct fraud claims against my client, Dr. Laporte, which was the only thing.
Well, didn't he claim that, didn't the plaintiff claim that in reliance on your client's failure to disclose what was going on with some of the expenses and stuff, that you got him to sell a portion of his ownership stake to your client, and they had been owning this together for 20 or 30 years, and you got it at maybe a reduced rate, and he relied on your representation? Isn't that part of what he's claiming?
It is part of what he's claiming, but what I'm saying, and what I would just finish with, is that the issues were disclosed to Dr. Brower. Dr. Brower, due to Anthony Mongelli's email in July 2009, that was disclosed. I thank the court for its time. If you have any further questions, otherwise I will rest.
Thank you. Thank you very much. Counsel, you have 2 minutes for rebuttal.
Justice Kapnick, just to respond to the first question you asked, the allegations start roughly about paragraph 90 of the amended complaint, and they carry on through 106. They conclude at 106, a very important paragraph. According to the November 15 letter, its conclusions were approved by a unanimous vote of the non-conflicted managers of the company, namely Arnold and Black. We allege that itself was a red flag because neither Arnold and Black were non-conflicted. They themselves had charged personal expenses to the company. They themselves had received undisclosed bonuses. They themselves had received forgiven loans, none of this known or approved by Dr. Broer. And so the whole process was tainted. This is not just a complaint about the result or motivations. This is a complaint about acts. There was some discussion earlier about how because this is a small company, somehow they can get away with this process. That's not true. We cite the case Seaford Funding, where if you present or make a demand to a company, a small company, where you're even alleging conflict, it is incumbent upon those directors or managers to act in good faith. Here, what they could have done, as they purported to do, was get DLA Piper to do the final conclusion, issue an opinion, get the accountant to issue an opinion, so there could be objective manifestations of exactly what happened. They
Counsel,
didn't-
can I ask a question? Going back to what you were saying during the first part of your argument, you talked about the motion to renew. The motion to renew was on which causes or which cause of action?
We moved to renew on the declaratory judgment that this personal spending was against the law, that it was improper, that it should not be done.
And the court never heard that either way. It just denied it because it said it was nothing new.
Correct. It said that the joinder of issue was not a new fact, which we submit is a legal error, that is a new fact under the case law that we cite in our briefing on that point.
So just and that was just on the which cause of action?
It was on that cause of action. It was for injunctive relief to stop this activity from happening. It was on indemnity to protect my client from their continuing to charge personal expenses and characterize them as business expenses. The 2008-2009, it is clear, according to their own statements, that they characterized as ordinary and necessary business expenses personal expenses. That's why we couldn't find out what they were, because they said, here, look at these financial statements in 2008 and 2009, travel and entertainment. One assumes that that's business related. Well, according to them, they could charge personal expenses, that it was personal expenses hidden in there.
Okay.
It's against the law.
Okay, we'll take a further look. Thank you all for.
Thank you.
Does anyone have any further questions?
Thank you.
Thank you very much. Have a nice afternoon. Thank you for coming in. Okay, the next case for oral argument is IKB versus Credit Suisse and Morgan Stanley. Please step up. Thank you. Okay, counsel, you may proceed. Good afternoon.
Good afternoon, Your Honor. Richard Dolan for the appellant. Plaintiff IKB sought leave to amend its complaint to state a claim for rescission based on mutual mistake.
I'm correct, am I not, Mr. Dolan, that the other causes of action are still in the case? The original causes of action, which the plaintiff moved, that there was a motion to dismiss, but the fraud causes of action are still there, correct?
Yes, Judge. Indeed, this court sustained them.
Right.
The last time, the two of us were here together.
That's
in
right, a few
2016.
years ago.
We come every 4 years, Judge.
Okay, I'll look forward to seeing you again.
The law is clear that the amendment should have been allowed unless the proposed new claim was, quote, palpably devoid of merit, which must be decided accepting plaintiff's statement allegations of fact as true. The motion court's order denying that motion should be reversed for several reasons. First, the motion court denied the motion and the request to amend because it thought that the alleged mutual mistake concerned valuation, but that was clearly wrong. The mutual mistake concerned the critical characteristics of the underlying mortgages which defendants were offering to sell and IKB was looking to buy. Those are the same, quote, critical characteristics that this court described in its 2016 decision.
Those are the same allegations that undergird the fraud claims, correct?
Absolutely, Judge. The factual allegations are exactly the same. The motion to amend did not add any new factual allegations. It's a very short new cause of action, purely legal, different theory, same facts. The distinction, which the motion court frankly just missed, was between a mistake about value and a mistake about fundamental characteristics of the subject of the transaction that impacts value. And the cases draw that distinction very clearly. And I want to go back to the foundational case. It's a charming 19th century case, which a lot of us read in law school. It's called the pregnant cow case. In that case, a buyer wanted to buy a cow for its meat. The seller was looking to sell a barren cow that would fit the bill. They agreed, apparently in a handshake deal, about the cow in question. Her name was Rosie, and the price was $80. When the buyer went to pick up the cow and tender the money, the seller refused on the grounds that the supposedly barren Rosie was actually pregnant. A pregnant cow, it turns out, was worth more than 10 times what a barren cow was. That dispute, like this one, concerned the critical characteristics of the property that was involved in the underlying transaction.
Counsel, should we fast forward to High Mount?
Sure, Judge. High Mount.
In High Mount, you had some securities that were supposedly not valued correctly, but the value of securities goes into the component parts of the securities, right?
No, I think, Judge, High Mount is a completely different case, and I'll get to that when I talk about reformation. But basically, in High Mount, that involved an allegation of mistake essentially about the price. High Mount was buying into an investment vehicle. It wasn't paying cash. It was an in-kind contribution. The parties have a detailed, I think it's a 100-page agreement going through everything. One of the terms is about price. And as this court's opinion in that case, as the last line says, the price term was actually fixed by a non-party to the transaction. It wasn't High Mount. They just had someone else fix the price. Along comes High Mount years later and saying there was a mutual mistake about that term, that the parties' oral agreement was somehow different from what was recorded in the written agreement. And on that, this court said, no, it's just a mistake about how the in-kind property was valued, not about what it was, not about any of its characteristics, critical or otherwise. It was just about valuation.
Can I ask you about another aspect or another issue?
Sure.
Which is the whole thing about, don't you need the existence of some kind of an agreement, a contractual agreement that in some material respect does not represent the meaning of the minds of the parties? I mean, on fraud, it doesn't have to be it doesn't have to be based on a contractual relationship, but a rescission does. And where's what's the contract that you're talking about?
Okay, Judge, that gets to the second mistake that was made, and I think it got a little confused. There are two different kinds of mutual mistake claims. One is reformation, and the basis of that claim is you've got a written agreement, just as in High Mount, that details everything, and one of the parties shows up after the fact and says that the written agreement is mistaken because of a scrivener's error. It says X, but the party's real agreement was Y. And that only works if you can show that there was an actual, the parties are agreed that the oral agreement was supposed to be one as opposed to the other. High Mount fails, among other reasons, because that condition wasn't even met. High Mount was saying the oral agreement was X, and the written agreement got it wrong, and the other party was saying, no, it was a completely different kind of thing. There was no mutual agreement as to the mistake. Rescission, which is the claim we're making.
Right, I understand.
Rescission says it doesn't focus on any particular term of the contract. What it says is the parties thought they were negotiating about X, and that was their mutual. The whole deal was we're valuing.
Well, they were negotiating about these RMBS.
Yes.
Which we now, in hindsight, all know for years the problems that there were.
Yep.
It turns out you hoped they were worth a lot of money, and it turned out they were worth very, very little money, and you lost a lot of money. But that's what they were worth. You knew you were talking about mortgages. You knew they were RMBS. What is it that you didn't know?
Judge, what we had.
I mean, you're saying that they. Okay, go ahead.
What we had, and what your opinion in 2016 details at some length, all we had was offering materials prepared exclusively by the underwriters and the sellers. It said the mortgages had this characteristic, that characteristic, loan to value, underwriting standards, all the rest of it detailed in your opinion. It turns out, after the fact, we know that wasn't true. There are two ways that they can defend this case. They can say They can say that it wasn't, we understood and we were wrong. We said this, but we said it in good faith and we were wrong.
Well, isn't that what you're alleging the misrepresentation is as to the fraud?
No, in fraud, you're not saying that they were acting in good faith. In fraud, you're saying they were lying to us, basically. Mutual mistake says, they say, and we'll accept this for purposes of the argument, we were acting in good faith. We were mistaken just like you were. We thought the mortgages were as described in the offering material. It turns out they weren't. We bought them on the assumption that what they told us about them was true. We had no way to do due diligence.
Can I ask you a different hypothetical? Say your beef is that the loan-to-value and combined loan-to-value ratios were bad for your client, that the owner-occupancy status of the loan mortgages was bad for your client, and that the mortgage loan originator's compliance with underwriting guidelines was not followed, and that was bad for your client. What if all three of those conditions were good for your client? Then, could the defendant get out of this because of mutual mistake?
Well, at that point, they would have to show that we shared their mistake, okay? We're relying on what they told us.
Okay, presume that. Could they then seek rescission?
I think the answer is no. I think it won't be because of mutual mistake, but as you saw in like the Eisenberg v. Hall, the art case about the sculpture, where the court sent it back saying there has to be, does the party who made the mistake assume the risk of the mistake? You sent that one back for analysis of that issue, so that maybe they could assert a mutual mistake case, but they're going to have trouble with all the other things that go with it. And the art case, in other words, it's a great case for us.
All right, you'll have 2 minutes
Thank you, Judge.
for rebuttal, okay? Thank you, Mr. Dolan.
Good afternoon, Your Honors.
Good afternoon.
Jim Rahonda on behalf of the respondents. Motions to amend are left to the sound discretion of the court. And here, although they say there is, motions to amend are freely granted, usually you have to make some showing and some factual showing. In fact, an important case is one of Your Honor Mazzarelli, your case, the Velarde case. You have to come forward with something. Here they came forward with nothing. They certainly, the standard of freely granting leave to amend doesn't apply where the claim itself is only allowed in exceptional circumstances. So you have to look at the claim itself. And what they are doing is making this claim ordinary. Take your securities fraud or your fraud complaint, change none of the factual allegations, and say if we can't prove that there was a misrepresentation as to value, then there was a mistake as to value. And we know and that would make these claims commonplace, not exceptional. Here, the subject of the exchange is pled by the plaintiffs. They plead in their complaints. There were certain certificates, certain prices, certain quantities, and certain dates that these transactions occurred. And they don't allege that there wasn't a meeting of the minds on those things. What they're saying is they're looking to statements and offering documents that they can't allege, and they have not alleged, were part of any sort of contract. And that is fatal to their claim. The idea that because...
What is the contract in this case that we're talking about?
Well, they never pled it. They did mention, and that was the exact question Justice Friedman asked, and they tried to say, well, it's set forth in the trade tickets and confirmations, and that would have included statements and offering documents. And the court rejected that and said because they had made no showing of that and they cannot make any showing that those were incorporated by reference. They certainly didn't plead it, that any of the other terms were made into a contract. In fact, they are saying the mere mention of a contract was error by Justice Friedman, which is completely wrong. It's certainly not a suggestion that she was mistaken about reformation versus rescission. If you look at the Simkin case, it says you can't figure out whether there's been a meeting of the minds unless you know what the essential nature of the agreement is. And Justice Friedman cited to that language in Simkin. So that's certainly not an error in any respect. And these things do go to value. I mean, the idea that these don't go to value, they're stuck with their complaint. Their complaint said over and over again, because again, they didn't come up with the different factual allegations. They said that the value, that they were unaware the value of the certificates was less than the purchase price, and that, in referring to these various representations, that meant the value of the certificates was impaired from the outset, and that these declines in market value were caused by misrepresentations. It's all about value, and that's it. The amended or proposed amended complaints of both Credit Suisse and Morgan Stanley, and they're found at at pages 153 and 341, Credit Suisse and Morgan Stanley, and they go on from there. And those are cited in our brief on appeal. So essentially what they've created is a fallback for fraud. No new allegations, don't even allege what the contract was, right? If they were going to amend, they should have at least said, here's what the contract was, this is what there was no essential meeting of the minds on these terms. They never did that. They had multiple opportunities to do it.
So isn't that fatal to this claim? Even if we don't go to the valuation, but doesn't it have to be based on some type of contractual terms that there was a mutual mistake about?
Yes, because that goes to either the terms of the contract or the subject of the exchange, which is the securities, or the foundation of the agreement. It's said various ways in this court's decisions and by the Court of Appeals. Those things all kind of get to the same thing, which is, was there a meeting of the minds on the subject of the exchange? Was there a foundational agreement? What were the terms of the contract? And that is fatal to their claim, and we think the separate grounds it is an allegation solely as to value. And I do think that they've made up sort of an argument that they might not be solely related to valuation. I see nothing in the cases announcing a rule like that. And they also seem to be saying that the judges pronounced that in all cases nobody ever could bring a mutual mistake claim in connection with a securities transaction. I do not think that's a fair reading of the judge's decision. She looked at the allegations here, found no contract being pled, even asked them at oral argument, and they still did not plead the terms of the contract. And that's because one could presume they can't plead statements about the collateral characteristics as the underlying loans, that those were terms of an agreed upon contract, as opposed to what are the sale dates, what are the prices, which certificates, what's the QSIP number for each of those certificates. That's what they failed to plead. Thank you.
Okay, thank you very much. Okay.
Judge, getting to the contract here,
Yes.
that's not remotely how this transaction goes down. What happens is you get offering materials prepared by the underwriters, prospectus, all of that, all describing your opinion. There is no written contract. You're imagining.
But the thing is, doesn't a rescission claim have to be based in that there was mutual mistake as to the terms of a contract, and it can't just be amorphous like, well, there was mutual mistake on whatever. And that's the problem. I mean, I think that cause of action is grounded in a contract. I know what these claims are about. I've had these cases, but that's why I asked you that question.
And I think, Judge, the answer, if you look at the Gould versus Board of Ed case in the Court of Appeals, that's the teacher tenure case. What that case was about wasn't any signed agreement. It was about a unilateral resignation letter submitted by a teacher because she thought she didn't have tenure, and the superintendent was telling her he would recommend that it be denied. There's no written contract there. She just wrote a letter saying, I resign. And the Court of Appeals sets it aside because the underlying understanding of the parties that led to that was a mistake about whether or not she in fact did have tenure. And the court said, yes, she did. That was the fundamental mistake everybody's operating on. There's no contract there. It's just a unilateral letter. The difference is, and it goes back to the difference between a reformation claim where you're asking a court to change the terms of a written agreement based on an oral understanding. In a rescission case, you're saying the parties went into this deal thinking, let me go back to the foundational case. I know that Judge Moten didn't like it, but let me talk about that very briefly. That's the cow case. And what they're talking about is buying a cow. Is it pregnant or is it barren? Everybody knows they're talking about a cow. It's just a handshake deal. The cow is worth a lot more if it can be pregnant. And the court sets it aside on grounds of mutual mistake. Obviously, it impacted on value, but everyone's talking about the cow. Here, it's really the same, and if I could just finish this thought. In this case, the issue is whether or not these mortgages were barren, i.e., were they never going to yield anything because they were subpar, or were they fertile? They were going to yield the yield because they were the top quality that they told us they were. That's the difference.
Thank you, counsel. Thank you both very much for coming in today. Have a nice afternoon. And our last case for today will be Benson versus Port Authority. Okay, counsel, you may proceed.
Good afternoon, Your Honors. Lee Eskenazi for the plaintiff appellants, James Benson and Christine Benson. May it please the court, I want to start by thanking the court for hearing argument on this case and indulging us to come before you this afternoon. We have two primary issues that we're dealing with today that arise from an issue going back all the way to 2010. This is a 2009 accident that occurred at the rebuild of the World Trade Center site. Plaintiff initiated an action resulting from concrete falling, being poured above into the forms, falling several stories, hitting him. The defendants have always disputed the occurrence of the accident. That's the primary liability. Plaintiff says it happened, defendant says it doesn't. With our initial discovery demands, which were served in December of 2010, we demanded, among other things, any photographs or videos that depicted the plaintiff on the date of the accident or the area where the accident occurred. It took several years of motion practice to try and get a response from the defendants. And ultimately, in May of 2013, nearly 3 years after the initial response, the defendants went in front of Judge Madden in the Supreme Court, New York County, and argued that it was their position the video didn't exist, that there was no photographic or video evidence from surveillance video, and that they shouldn't have to disclose any more than that because of the sensitive nature of the rebuild, claiming national security interest privilege and law enforcement interest privilege. I'll concede and get into it a little bit more later that, of course, after 9/11, that was a very sensitive topic, and of course, I don't blame Judge Madden in any sense of the word for siding with the defendants. But what we've learned since that day, and since Justice Madden issued her order in May of 2013, is that there was a company, a private company, that had a contract with the Port Authority.
Project Rebirth.
Correct.
We saw that in your brief. So the question is, why can't you just make a request to get the video from Project Rebirth? I mean, Project Rebirth is not the same as the Port Authority. It's a separate entity. It's a private company.
No, of course, Your Honor. That is correct. They are separate entities. They did have a contract that permitted Project Rebirth to film footage at the site over the course of years to produce a documentary for public consumption.
Right.
But the issue here is not whether they're separate and distinct companies. The issue here is the control over the video. The CPLR standard is possession, custody, and control.
So how do they have control? How do you allege
So they have
that
control through constructive possession of the goods. And we look at the Court of Appeals determination in the Commonwealth of the Northern Marina Islands versus the Canadian Imperial Bank of Commerce. There, all you need to determine constructive possession and control is the ability and right to request and obtain the subject video footage, even if it's in the possession of another entity. Here, the contract gives the Port Authority a slew of rights as to their ability to request copies of the footage for a number of reasons, including receiving copies of archival footage at any time, And I refer the court to page 465 of the record for that clause. That's the standard. And if that wasn't enough, the same attorneys that are sitting here today to argue against this motion in a case before this court used the footage from Project Rebirth, the Giordano case against Tishman Construction. Those photos were brought and obtained in connection initially with a motion to re-argue that was filed in May of 2015, then used before this court on appeal. And upon information and belief, even though the Port Authority wasn't a direct defendant, it's all wraparound insurance, and Tishman Construction was the general contractor. They were able to get the photos then. In this case, they didn't subpoena or even attempt to get the photos until November of 2016, nearly a year and a half after they introduced them in another case from Project Rebirth. So this is something the Port Authority can't hide and say, we didn't know that this existed. They had a contract with Project Rebirth. They can't say, we didn't know this existed. They've used it in other cases. They have control under the CPLR. And I just want to shift, because I know my time is running out, to the sealed affidavit, which is the second issue here. As I alluded to and mentioned earlier, of course the court went and deferred to the national security interest.
Well, I'm sure, look, the judge reviewed it and she made a determination, so I don't think you'd say it's just because it was their, security is an important issue, but I'm sure she made an independent determination.
Well, the point was, one of the reasons I wanted to come before the court today was Justice Madden was handed an affidavit that she reviewed in camera at the bench. I was present that day. I had the opportunity to review it for maybe 15, 20 seconds. Neither Justice Madden nor myself had any knowledge of Project Rebirth at that time. So the affidavit was placed under seal. And part of the motions that we made following finding out about Project Rebirth is to unseal the affidavit and to move forward with this case. Because you can't claim national security interests when you have a contract to allow a documentary for public consumption to be made. And it's their burden to show that it still exists. Here, not only was the affidavit sealed, but there was more delay and damage caused because the other part of that was that Justice Madden then determined, based on their claim of privilege, that we couldn't even inquire of the witnesses as to the existence of video footage. We've done in excess of a dozen depositions of defense witnesses trying to get to the point of whether or not this incident occurred the way the plaintiff alleges. That could have been obviated if they lived up to their discovery burden under the CPLR back in 2010, 11, 12, 13, all the way up to 2020 today. They failed to do so, causing 10 years of litigation, unquantifiable expense and delay to the plaintiff, all under the guise of, well, it's a different company. But that's not the standard.
Okay.
Thank you.
Thank you.
Thank you. May it please the court. My name is Dinesh Dedlani from Siegel, McCambridge, Singer, Mahoney on behalf of respondents, the Port Authority of New York and New Jersey, and Phoenix Constructors. So may it please the court, I just, to address plaintiff's counsel's argument with regard to custody, possession, and control, that's what this really boils down to in regard to the Project Rebirth video. Port Authority never had custody, control, possession of...
What about the point that he made about Port Authority using the footage in the Giordano case?
So, Your Honor, in that case, the Port Authority paid for that footage. They didn't simply get it. They had to actually pay for it.
Okay, so now you already paid for it, you have it, so it's in your custody, so give it to them.
No, we don't have it. We don't. That was. And I want to preface this by saying I was not involved in the Giordano case, so I can't really get into the specifics.
But somebody else from your custody.
Well, but my understanding is that was a different area of the World Trade Center, not this particular area, so it wouldn't have. And I'm not even sure if the timeframes were the same. So we don't. What my understanding is that they got in that was just something specific to the area where that accident took place. We don't have. The Port Authority did not get the entire. The entirety of what Project Rebirth had. It was something just very specific. So in this case, that's essentially when the Port Authority first issued a subpoena, it was just asking for anything that they may have had with regard to this specific area where the incident occurred. The response we got back, which was the same thing that plaintiff got back, was that if you want us to do the search, it will cost the Port Authority $10,000 for us to conduct the search and provide you what we have. Exactly the same.
It's going to cost the Port Authority $10,000 to do the search?
Yes.
What do you have to do?
I'm sorry?
What do you have to do?
Well, I guess Project Rebirth has to pull the, I guess, pull the footage out of an archive and do it, and I guess run searches of what they have. And they estimated that the cost for that would be approximately $10,000, and the Port Authority, if they wanted that footage, would have to pay the $10,000. This is the same thing that plaintiff was told.
You've been fighting about this for 10 years?
No, we have not been fighting about this for 10 years. I think this has been the last year. Maybe I think this came up in motions in approximately 2019. There's been other issues that have cropped up in this case.
This appeal costs more than $10,000.
I'm sorry?
This appeal costs more than $10,000.
Well, but Your Honor, what it comes down to is whether the Port Authority had custody of this. I mean, possession or control. The contract is clear that the footage is the sole and exclusive property of Project Rebirth, not the Port Authority. And again, if the Port Authority wanted it, it had to pay for it. That's the same access that plaintiff has to it. The Port Authority does not have any other access to it other than the
The
same.
two of you couldn't have split this? Wow, I'll tell you. I mean, I know I'm not in the trial court, but.
I mean, so, Your Honor, that's what this argument is. That's what this argument is boiled down to with regard to the custody, possession, and control, and that plaintiff has said that that the Port Authority should have to pay for this because they had this agreement. It was in their possession. That's not what the agreement says at all. The agreement is very clear that it's solely the ownership of Project Rebirth, not the Port Authority. They have no intellectual property rights in it. They do not have it. If they want it, they can request it, but they have to pay for it. It's clear in the contract that anything that they want remade or reproduced for their own purposes has to be paid for.
So you paid for it in the other case too?
In that other case, it was paid for. Yes.
Port Authority paid for it? You don't know?
I'm not sure if it was Port Authority or another defendant, one of the contractors. I'm not sure about that.
Mm-hmm.
But it was paid for. It was not just given or just simply requested by the Port Authority and given over by Project Rebirth. The same way they would have to pay for it in this case was the same way they paid for it in that case.
What about the sealed affidavit? Is that stale in some way, or have circumstances changed because of the reveal of Project Rebirth?
I don't think so, Your Honor, because just because a third party was allowed to film from some part of the or film some areas of the World Trade Center doesn't mean that the information that the Port Authority was required to provide, which was location of surveillance cameras, should be able to be disclosed to everybody.
Because the affidavit concerned specific surveillance cameras, not the Project Rebirth cameras.
No, it went to the Port Authority surveillance cameras. Right. So it was the location of where Port Authority security cameras may not have been in regard to the location of the accident. And Judge, that was our argument, in that it still goes to the fact of the Port Authority's procedures and policies with regard to security cameras it places on construction sites, and that it should still be adhered to and protected, because frankly, it really does not go to plaintiff's issue of the production of Project Rebirth. So when balancing it out, the balance clearly falls in favor of the Port Authority here to keep that protected.
Okay, thank you both very much.
Thank you.
Your Honor, actually, may I have 30 seconds of rebuttal?
I didn't give you 30 seconds, so I'm sorry, I just gave you each the 5 minutes. So we will take a look at these papers again. Thank you both very much for coming in. Have a nice day.
Thank you.
You're welcome. Have a great